So, in the last class, we have discussed till section 155 to 157. And under the provided section, we have discussed about the mixing of the goods. Under that, we have discussed in the details that when the goods has been mixed with the consent of the buyer or without the consent of the buyer, then what is the consequences in this? This is what we have discussed in the last class. Okay. So, providing the summary regarding the latest session we have discussed. Under section 155, we have discussed when the goods are mixed with the consent of the buyer, then the buyer and the belly share the mixture based on their proportion. For example, uh, there is the consent of the buyer to mix her or his own goods with the goods of the belly. Okay. For example, there is 15 kg of the rice that is at the belly's house. Okay. The beller is coming to the belly and asking the belly to keep his own rice at belly's place. Okay. And it is the given consent by the beller to mix the rice of the beller with the rice of the belly. The beller who is bringing rice to the house of the belly, that is up to the amount of the 5 kg. But previously, the belly has 10 kg of rice at his home before ahead. So when the beller is coming to the belly and giving his consent to mix up the amount of the rice with the rice of the belly is mixing the things and keeping it with a proper protection. So when it comes about taking back the things, the beller is responsible or liable to get up to the amount of the 5 kg of the rice only, because there was the 10 kg of the rice before. The beller provided 5 kg of the rice. So the previously given 10 kg plus the given 5 kg rice of the beller, it produced 15 kg of the rice in all total. And it has already been mixed together. It is unable to separate the rice of the beller from the rice of the belly. So in that specific circumstances, this is the duty or this is the responsibility of the beller to get back the specific proportion of the amount which he has given. For example, if the beller has given the 5 kg amount of the rice, then he has to take back that specific amount of the rice only. That means if the amount of the rice is 5 kg that beller has given to the belly, then beller is responsible to take back the amount of 5 kg of the rice from the belly. It cannot be specified that the beller is responsible to take the rice which he has provided to belly. It is not mandatory because the rice has already been mixed up. It is unable to separate the previous thing from the new one, right? So from the mixed product, the beller is liable or responsible to get the specific amount which he deserves according to his proportion. According to his proportion, he has provided 5 kg and the belly had 10 kg. So here the proportion is 1:2. So here, if the whole amount of the rice will be divided in 3 parts, the baler is responsible to get 1 part of the rice, and the rest 2 part of the rice will be given to the belly. Got it? Then comes the mixing of the goods without beller's consent. So when we are talking about the beller's consent is not there, okay, So what will happen in that situation? If the goods are mixed without the consent but can be separated, the belly must bear the cost and any damage occurred. As cotton bales are mixed with bees, and B must separate them and pay them for the damages. Okay. So what does it mean? It means when we are talking about the consent of the baler, in the first thing, there is the clear consent of the baler on that specific act under section 155. But in the second case, there is no consent of the baler to provide the goods. Okay. So when there is the absence of the consent of the baler, if the goods are mixed without consent but can be separated, but the belly must bear the cost or any damage that has been occurred. Okay. According to section 156, okay, when the goods are mixed without the consent of the bearer, then what will happen in that case? Okay. If the goods are made without mixed without consent, but the goods can be separated, then the belly must bear the cost and any damage that caused. Okay. Okay. So let me give you an example of this. For example, I am the beller and you are the belly. Okay. I have given you up my certain things which you have kept keeping it carefully, to keep it carefully or to take care of it. Okay. But unfortunately, my goods has been mixed with your goods. It can be separated, but when we are talking about the uh, cause of the mixture, okay, it can be separated, but when we are talking about the cause of the separation, cause of the mixture, then we got to know that the belly is definitely going to face certain kind of the difficulties and damages. Okay. So here, without the consent of the beller, if the goods are mixed without the consent, but the goods can be separated, then in that specific cases, the belly must bear the cost or any kind of the damages that has been caused. Okay. So when we're talking about the if the goods are mixed without consent but can be separated, the belly must bear the cost and any damages occurred. Okay. Then comes section 157, which speaks about when the mixture of the goods cannot be separated from each other, when it is closely attached with each other, or when it is unable to be get separated from each other. What will happen there? If the goods cannot be separated, the belly must compensate the bearer for the losses or the damages. The answer is very simple, that if the goods of the belly cannot be separated, okay, then the belly must compensate the bearer and the bearer for the loss. Okay. That means if the goods cannot be separated, if it is a situation where the mixture has already been happened and it is seen that it is impossible to derive the mixtures, it is impossible to separate the mixtures of the goods, then in that specific case, if the belly is facing any kind of the problem, then the belly, if the beller faces any kind of the issues, then the belly must compensate the beller for the losses or the damages. So according to law, if the goods cannot be separated and the goods belongs to the beller, okay, so here the belly must compensate the beller for the losses and the damages. Okay. Then comes your section 158, which speaks about the necessary expenses. Okay. So when we're talking about the necessary expenses, if the belly is not paid for their work but incurs necessary expenses, the bailior must repay them. Example: A keeps clothes to B for the free storage. B spends on pest control to protect them. And in these specific circumstances, it is the duty of the A to reimburse the B. Okay. So when we're talking about the necessary expenses, at least we know that the belly is not paid for the work but incurs the necessary expenses. Okay, the bailior must repay them. Okay, and that is why A keeps clothes to B for free storage. A spends on pest control to protect them, and A must reimburse B. Okay. Then when we're talking about section 159, we're talking about uh, the lender. We are talking about the return of the gratuitously lent goods. Okay. Section 158 we discussed about the necessary expenses, but section 159 we are discussing about the return of the gratuitously lent goods. Okay. So what is it? It is explained under section 159. Okay. Then first, let's have a conversation. When we are talking about section 158, which speaks about the necessary expenses. What are the necessary expenses on this? Okay. So under section 157, we have discussed when the goods cannot be separated, then the bailey must compensate the bailior for the losses or the damages. Okay. Then comes section 158. This speaks about the necessary expenses. Okay. So when we're talking about the necessary expenses, under that we have understood that if the belly is not paid for their work but incurs necessary expenses, the bailior must repay them. Okay. For example, I am working as a belly for a specific person, okay? And to protect the goods of that specific person, I have to take care of the things of that specific person. And that is why I have to buy something or I have to take care of the things in a certain manner. So, in that specific circumstances, whatever the expenses are there, okay, as a bailior, this is the responsibility of the bailior to repay the bailey for that specific expenses. Okay. So under section 158 it is clearly spoken that if the bailey is not paid for their work but incurs the necessary expenses, then in that certain circumstances, the bailior is responsible or liable to repay them. Okay. Then comes section 159. It speaks about the return of gratuitously lent goods. Okay. So under section 159, it is spoken that the lender can ask for the return of a loaned item at any time, but if this causes a loss greater than the benefit received, the lender must compensate the borrower. Okay. So it means when we're talking about section 159, it speaks about the return of the gratuitously lent goods. That means the lender, the person who has lent the goods, okay, can ask for the return of the loaned item at any time, But if this causes a loss greater than the benefit received, the lender must compensate the borrower. That means, for example, you have taken the amount of uh, 15,000 rupees from me. Okay. So, in the exchange of the 15,000 rupees, you have given me any specific thing. For example, your just take an example. This is a golden ring. Okay. When you are you want to take the amount of 15,000 rupees from me. So in return, I am giving you this ring. You are taking this ring from me, and in return you are paying me the amount of 15,000 of the rupees. So you are giving me the loan amount of 15,000 of the rupees in the exchange of this specific ring. Okay. That means रिंग के बदले आप मुझे 15,000 रुपया का लोन दे रहे हो. ये हो गया ना पहली बात. दूसरी बात आता है when it comes to the point that रिटर्न ऑफ द ग्रेटुइटियसली लेंट गुड्स. ये जो रिंग है ना, अगर जैसे कि हम दोनों के बीच में डील हुआ था कि 2 महीने के अंदर I have to repay the amount of 15,000 of the rupees. Got it? So when there is the deal between you and me that I am supposed to pay you the amount of 15,000 rupees in the duration of 2 months. So when that specific duration is been completed, when that specific duration is done, then after the completion of that specific tenure, after the completion of that specific term, the lender who has taken the goods must give back the lent product or lent item to the person who has given the goods, and the person who has taken the money from the lender is responsible to pay back the amount in between the specific time duration. That means, for example, I have given you this ring, and in return I have taken the amount of 15,000 rupees from you. So here I have taken a loan amount from you up to the amount of 15,000. ये रिंग को आपके पास बंधक रख के मैं आपसे 15,000 रुपया का लोन लेके गई हूँ. ये हो गई बात. ओके. जब हम दोनों के बीच में ये डील है कि 2 महीने के अंदर ये लोन क्लियर करनी है, 2 महीने के अंदर ये लोन चुकाना है. सो हियर दिस इज माई रिस्पॉन्सिबिलिटी कि हाँ, मैं ये जो 15,000 रुपया लिया हूं उसको मैं 2 महीने के अंदर ही चुका दूंगी. एंड वंस आई रीपे द लोन अमाउंट, एक बार मैं अपना सारा लोन अमाउंट जो है ना उसको रीपेमेंट कर देती हूँ. कंप्लीशन ऑफ द पेमेंट अगर एक बार से हो जाता है, then it is the duty of the lender to give back the specific good which he or she has taken. अगर वो मुझसे 15,000 रुपया का बदले सोने का कोई सामान लेके रखा है, देन उसका ये ड्यूटी बनता है कि उसी को अपना पैसा मिलते ही मेरा जो सामान उसी ने आज से बंधक के तौर पे रखा था, आज ये सिक्योरिटी रखा था, आज ये गारंटी रखा था, वो सामान वो मुझे वापस कर देगा. ये कोई हो गया आपका पहली बात. दूसरी बात, दूसरा सिचुएशन ऐसा है कि अगर जैसे कि द लेंडर हैज गिवन मी द अमाउंट अप टू 15,000 ऑफ द रुपीज, और मुझे 15,000 रुपया तक ही दिया है. ओके. मान लो देयर इज ए सिचुएशन, ओके, वेयर I am unable to repay the amount in the duration of 2 months. 2 महीने के अंदर मैं उस पैसे को नहीं चुका पा रही हूँ. So here, what is the responsibility of the lender? Here, the lender must compensate the borrower with the remaining amount. If the lender it's selling this golden ring somewhere, how much amount he would approx get? At least up to the amount of 50,000 or 60,000. Take an example of this, okay? And when we know that the lender can ask the return of a loaned item at any time, यहाँ पे जो लेंडर है ना वो एनी टाइम अपना जो भी लोन्ड आइटम था उसका रिटर्न के लिए बोल सकता है. दूसरा क्या है? But if it causes a loss greater than the benefit received, the lender must compensate the borrower. That means when we are talking about it causes the loss greater than the benefit received. For example, I have given you the ring, this golden ring, in exchange of as the security of 15,000 of the rupees. So when I am unable to pay you, okay, when I am unable to pay you the specific amount as a borrower, then you are going to sell this golden ring and getting money from the shop, and you are getting up to the amount of 50,000 from the golden shop. Okay. So when you are selling this ring, you are getting the amount of 50,000, but your actual due is 15,000 only. Got it? Your actual due is 15,000 only, but you are getting more than that 50,000 around. Okay. So when we are talking about the return of the gratuitously lent goods, we have to understand that when there is the gratuitously lent goods has been done. Okay. Then if it causes any kind of the losses greater than the benefit received, for example, जैसे कि मैंने आप लोगों को बताया, for example, I am giving this golden ring to you in the security of the amount of the guarantee of to the 15,000 of the rupees. So when you are going to the golden shop and selling this item, you are getting the amount up to 50,000 of the rupees. But your actual due to get the payment is 20,000 of the rupees. So how much time I am getting over here? It is around 30 minutes. Okay. So when we are talking about the return of the goods, then there is the concept of the return of the money also. If the gold jewelry has been costed up to the amount of 50 to 60,000 of the rupees, and mind you is actually 15,000 of the rupees, then I do not have any right to keep the whole property of yours, the whole money of yours, right? I can what I return the goods, or I can when I'll return the goods to the seller, or the person who has taken the money, or the borrower, or if he causes more losses, or or more benefits, then it is a good thing. And if it causes more the benefits rather than the losses, then the lender must compensate the borrower itself. Okay. Then comes, we are talking about the duty to return home goods. Okay. This is explained under section 160, and this is exactly speak that the belly must return the goods once the time or purpose of the bailment is over without waiting for a demand. Okay. Before this we are discussing section 159. Okay. So under that we have discussed that the leader can ask the lender can ask the return of the loaned item at any time, but if this causes a loss greater than the benefit received, the elder must compensate compensate the borrower. So here it is the duty of the elder, or the lender, to compensate the borrower. borrower को compensate करना किसका ड्यूटी है? This is the duty of the lender to do it. Okay. So under section 159, we have discussed one more thing. Okay. So when we're talking about the losses greater than the benefits received, or the benefits are greater than the losses, then the lender must compensate about the borrower. Okay. Okay. So this is about the concept of the section 159. I'll add one more thing here. We have understood the concept of the bailor and the bailee. The person who provides his or her own goods for the process of the bailment is called the bailor, and the person to whom the specific things has been provided is called the bailee. Okay. So when we're talking about the concept of the bailor and the bailee, when we're talking about the concept of the bailor and the bailee, here when this is the thing of gratuitously giving the loan. Okay. That means when there is something which taking gratuitously, that is also called a kind of uh, uh, taking that is also called a kind of the thing in which you take something, the exchange things in which you are taking something and you are giving something. Okay. So when we're talking about the gratuitously lent goods, the person, for example, I need money and I am giving this ring of mine as the gratuitous product. Okay. So when someone is providing any kind of the gratuitously lent goods explained under section 159. Okay. When we're talking about the person who is providing the gratuitous goods is called the person who is providing the gratuitous goods, and the lender must compensate the borrower. The person who has lended, he must have compensated from the borrower. Okay. So here, if this causes a uh, any kind of the losses rather than the benefits received, if it causes any kind of the losses rather than the benefits received, then in that specific circumstances, so in that specific circumstances, the lender must compensate to the borrower. Okay. This is about section 159. We have discussed who is a person, the person who gives the thing is called the person who gives the thing is called the borrower. In return of the specific thing, he is taking something, and the person who receives the thing is called the borrower. Got it? Okay. So when we are talking about section 159, we have discussed over here about the loaned item. For example, I am taking loan from the bank, or I am taking loan from a specific institution. I have to assure the institution about my clarity of the payment, that yes, on time to time I am going to provide my money. So this, to give this assurance to the specific institution or organization, or to the specific person, I have to give him something which will give trust in that specific person's heart. So here, this is called the concept of the bailor and the bailee. Here the person who is providing own goods, for example, I am providing my golden ring in the expectation of 15,000 of the rupees. So here, this is the thing where the lender can ask for the future of the loan, future of the future of the loaned property. Okay. So the property or the goods which has been lended, which has been taken as the loan amount has been taken, that must be repaid, the first thing. And the thing which has been given in return of the specific goods. After the payment, that goods must be given back to the borrower by the lender, or by the belly, it must have been given back to the bailor. Okay. So now come to under section 160. This speaks about the duty to return the goods. Okay. So when we are talking about the return of the gratuitously lent good under section 159, what does it mean? The lender can ask the loaned item at any time, but if it causes a loss greater than the benefit received, then the lender must complete it. Okay. And the lender must compensate the borrower itself. So when we are talking about section 160, the bailee must return the goods at once the time or purpose of the bailment's over, without waiting for a demand. Okay. And the most important thing is, like, when we are talking about the gratuitously lent goods. Okay. And we have discussed that duty to return the goods under section 160. So, as a bailor, when I am giving you something for the sake of the money, and when you are getting your money, then it is your responsibility to send me back my specific thing which I was supposed to get. This is called a duty to return the goods. This is the first thing. The second thing is, uh, the bailee must return the goods once the time or purpose of the bailment is over, without waiting for a demand. Okay. So when this concept of the bailment is over, I have taken the amount of 15,000 of the rupees from you, and in return I have given my golden ring to you. So when I have come back, when I have taken back, I have given you back the amount of 15,000 of the rupees, then in return, I am also liable, I am also responsible to get back my goods in return. The bailee must return the goods once the time or purpose of the bailment is over, without without want for a demand. Okay, got it? So when we are talking about the duty to return of the goods, we discussed that it is the duty of the bailee to return the goods once the time or purpose of the bailment is over, without waiting for the demand. And when the time or the purpose of the bailment is over. Okay, so when the time or purpose of the bailment is over, without wailing the belly, without waiting for a demand. Okay, so once the bailment is over, when the bailment duration is over, then in that specific circumstances, the bailee must return the goods once the time or purpose of the bailment is over, without waiting for the demand. Then comes section 11. This speaks about the responsibility for the delay. Okay. So when we are talking about the responsibility of the delay, it means if the bailee delays returning the goods and they are damaged, the bailee is responsible for the losses or the damages. It means if the bailee delays returning the goods and they are damages, then the bailee is responsible for the losses or the damages. For example, I have given you my golden ring. For example, I have given you my golden ring in exchange of the 15,000 of the rupees. Okay. So when you have kept this golden ring near you, and I have paid you the specific amount of the 15,000 of the rupees in a specific time period, I have done the payment to you. So once you are receiving the payment from me, it is your duty to pay me back. It is your responsibility to pay me back the specific amount itself. or it is your responsibility to return me the goods which I have given to you, right? So when the belly delays in returning the goods, it might be intentionally or unintentionally. For example, I have given my clothes near you for the purpose of dry washing. You were supposed to provide me my clothes after the specific work of dry washing in the duration of 3 days, but you are doing the intentional delay. I have given you back the amount of 15,000 of the rupees. So you were supposed to give me back my ring which I have given you to one to gain trust inside you. So these things when it is happening, when the belly delays returning the goods and they are damaged due to the delay from the beller's side, due to the delay from the belly side, the goods are damaged. Then in that specific circumstances, the belly is responsible for the losses or the damages. Got it? This is explained under section 161 that if the belly delays, when there is a beller, there is a belly and the belly has taken the goods from the beller and the belly is knowingly doing the delay to return the goods, and due to this the goods are damaged, then the belly is responsible for the losses and other damages. Okay. Then the last point under section 162, it speaks about the termination by death. A gratuitous bailment ends if either the beller or the belly dies. For example, there is a condition between the beller and the belly that the performance of the work will only happen with the beller and the belly. There is a beller who used to do work for me, or there is a mechanic who used to rectify my electronic instruments. Okay, so I have given my instruments near that specific person for the purpose of repairing it. So I am the beller over here who is doing the contract of the bailment near my employee to repair the electronic instruments. But unfortunately, before the completion of the task, this is called the gratuitous bailment. Before the completion of the task, the beller or the belly is been dead. Any one of them, either the beller or the belly is dead. So here, if the beller is deader, who will receive the product? There is no one to receive the product. And if the belly is dead, who will take care of the product? No one. So here the contract of the bailment automatically comes to an end because when the belly dies, he is unable to take care of the specific goods, and when the beller dies, he is unable to receive the goods from the belly. So here the gratuitous bailment ends when either of the party dies. It might be the beller, it might be the belly. If any of the party dies, then the gratuitous bailment ends over there. So from section 163 onwards, we are going to discuss in the next class. This is all for today, guys. We can end the class here. Thank you. Bye bye.